Morning, my name is Lauren Strax, and I'm with the MLF legal firm, and I'm here to discuss the 2018 appeals panel decisions, and I'm going to separate them into three main categories. It's going to be finality, and also a case on disability, and the main big kahuna is going to be extent of injury and headache cases. So, first of all, with regard to disability, I'm just going to touch on appeal number 180294. The ALJ in that case determined the claimant did not have any disability, and this was a special education teacher, and what essentially happened was that the employer had what is called essentially assault leave policy benefits. The claimant was collecting these benefits, and the appeals panel found that she was eligible to additionally recover her temporary income benefits as well, as long as the total compensation from the two of those benefits together does not exceed the 100% of her weekly rate of pay. So as long as the code provides that notwithstanding any other law, assault leave policy benefits due to an employee shall be coordinated with temporary income benefits due to workers' compensation so that the employee's total compensation and assault leave policy benefits equals 100% of the employee's weekly rate of pay. And additionally, the court also found that the assault leave benefits were not given to her in exchange for employment or for work that she was providing. So they were not considered wages by the judge. So that's one of the significant cases. And finally, with regards to finality, the main rule to come out of this case is that the DWIG 45 is effective as of the date it's filed to dispute the first certification of MMI and IR only once it has been submitted, approved, and a BRC has been scheduled. The DWIG 32 is effective as of the date it's filed to dispute the first certification of MMI and IR. So this was a very fact-intensive case where essentially the basically the appeals panel found that they went back first, and this is appeal 180848S. The court looked at APD 043023S, and this was decided back in 2005. The filing of a DWIG 32 stops the 90-day clock the day it's filed, despite it being incomplete. So in that case, when the carrier filed the 32, requesting a designated doctor to dispute the treating doctor's first valid certification, it was incomplete, and the appeals panel affirmed the ALJ's determination that the DWIG 32 was sufficient to dispute the first valid certification of MMI and IR. And as to the recent case, the appeals panel found that when the 45 is essentially effective, it's when the ALJ is determining when the first certification of MMI and IR, in this case was from Dr. DG, which was a treating doctor referral, was becoming final. The judge, administrative law judge in that case, erred because they did not consider the fact that the claimant filed a 45 and a 32 before the expiration of the 90-day period. So they were disputing the first certification of MMI and IR. The evidence did show that the 32 was denied because it was incomplete in that case. However, just like in the previous appeals panel decision, that I described, which is 043023, the appeals panel determined that a DWIG 32 representing the appointment of a designated doctor, even though returned as incomplete, was sufficient to dispute the first certification of MMI and IR as of the day it's filed. But with the 45, the appeals panel cited Rule 141.1, which provides that after a complete request is submitted, approved, and a BRC is scheduled, the party has established a dispute the first certification of MMI and or impairment rating in accordance with the section effective as of the date the request was filed. So all three of those elements are required for 45 as opposed to the 32, which refers back to the date that it was filed. So this is a really important case with regards to practice. We can derive that the 45 is effective as of the date it's filed to dispute the first certification of MMI and IR as long as it was submitted to the division prior to the expiration of the 90-day period and approved by the division and the division scheduled the BRC. So all of those three elements are absolutely required, which differentiates it from the 32. And now for a really exciting trend that's been going on in the appeals panel, which is with regard to extent of injury. Just to cover briefly, extent of injury, depending on what it is, could require expert evidence or it might not. So in some cases, as we're all aware, we can have cases where we don't require expert testimony. And one example that the appeals panel has held is that contusions, sprains, and strains do not require expert medical evidence of causation, and that is from appeals panel decision in 2013, which includes all three of them, and that's 131252. Additionally, the appeals panel did find in 2014 that fractures can also be compensable without medical evidence based on the facts of the case and the mechanism of injury. So this was a case where a gentleman was working as a prison guard. He was assaulted by an inmate. The inmate punched the claimant in the face several times. The claimant suffered multiple injuries to his face area. He went to the hospital 6 days later. He had x-rays, and 6 days later, when he had those x-rays in the emergency room, they revealed that he had sustained fractures to the tip of his nose, and the administrative law judge's determination that his injury does not extend to the nasal bone fracture was reversed and rendered by the appeals panel because they found that it was against the great weight and the preponderance of the evidence as to be clearly wrong and manifestly unjust. Another thing to point out is that the court does look to see if the injury or damage that was caused by the accident is shown that it naturally flows from the original injury itself. So the court is going to say it is only meant that the injury or damage caused by the accident is shown to be such that it is natural for the disease to follow therefrom, considering the human anatomy and the structural portions of the body and their relations to each other. And that's a really critical point, because when you look to these headache cases, this isn't a situation where somebody's just complaining about headaches in an isolated situation. These cases that I'm about to list, and there are 4 of them, show that these are very serious head traumas. These are very serious head injuries. And the court does have a previous case in 2015 where I'm just going to show where that trend kind of began. The appeals panel stated that under the facts of this case and with the described mechanism of injury, we declined to hold that expert medical evidence was required to prove headaches. And a significant fact from this appeal, which is appeals panel decision 142523, it is undisputed that claimant's head struck a metal door frame with such force that she lost consciousness. Numerous records and evidence from 2 days after the date of injury onward diagnosed the claimant with headaches. So when we look at appeal number 180458, some significant facts to document is that the claimant presented with head pain, and a CAT scan was performed based on the acute head trauma that the claimant suffered. And additionally, the diagnosis provided in the claimant's assessment, the medical records diagnosed an acute head injury, and there are numerous medical records and evidence that document the claimant's headaches. So in that case, the administrative law judge was reversed by the appeals panel because they found that it was so against the great weight and preponderance of the evidence as to be clearly wrong and manifestly unjust. And that's what they're going to say with each one of these cases as they proceed to go forward and reverse all of these judges. So one other following case would be Appeal 180602. And this is a really critical fact that the next several cases mentioned. The claimant was transported from the scene of the accident to the hospital by ambulance. The claimant complained of head pain. The claimant's laceration was closed with staples. And additionally, numerous medical records and evidence document claimant's headaches. Appeal 180603, the ALJ determined that the compensable injury extends to a traumatic brain injury. Claimant was transported from the scene of the accident to the hospital in an ambulance. Claimant had pain in his head. Numerous medical records and evidence document the claimant's headaches. Appeal 180702. The claimant testified she had headaches after the state of injury. Numerous records and evidence document claimant's periodic headaches. Claimant was transported from the scene of the accident to the hospital by ambulance. And the reason that this appeal is significant is because associated periodic headaches can be a compensable injury. That's very significant. So we go from headaches can be a compensable injury to associated periodic headaches. So if the facts are right, you can even have associated periodic headaches. And based on all of these cases, the court ruled the same way regardless of if the designated doctor was in agreement with the claimant with regard to their extent of injury or not. So when the designated doctor agreed, the court was still in agreement with the claimant that they had sustained headaches as part of their compensable injury. Even when the designated doctor found against the claimant, the court still agreed. The court is going to look to basically the severity of the head injury, the mechanism of the injury, the testimony provided by the claimant, and the medical records that are in evidence. So obviously the appeals panel has definitely displayed a trend that they do not believe that headaches require expert medical evidence, and they are focusing on the fact that headaches are now considered a condition within the common knowledge and experience of the fact finder. So the appeals panel is going to look to the evidence that's on the record to determine whether the headaches are naturally flowing and naturally resulting from the compensable injury suffered by the claimant. So that concludes the significant appeals panel decisions for 2018. Thank you very much.